The Model Code and rules promulgated by the American Bar Association. There is no national license allowing lawyers to practice across all the United States. Laws are often state-specific, and licensing of lawyers is implemented on a state-by-state basis. Each state has its own bar with its own rules of professional conduct, admissibility, licensing rules, and disciplinary rules. Under the U.S. Constitution, each state has broad discretion to set the standards required for admission to its bar. Only a rational relationship between the state requirements and the fitness to practice law is necessary. However, a state cannot restrict admission to residents of that state and must consider any U.S. citizen for the bar. A resident of Nevada cannot be prevented from admission to the California bar merely because she resides in another state. As the practice of law requires a license, it's important to understand what is and is not the practice of law. Some areas are more obvious than others. Representing a client in court is clearly practicing law. An individual client has a right to choose to represent himself or herself, but a corporation cannot represent itself, and a licensed attorney is required to represent the corporation in court. There is an exception allowing law school students to represent some clients in court in some situations. The practice of law also covers the drawing up of legal documents for others. Individuals, however, can draw up their own legal documents if they wish, and so can the officers and employees acting as agents for corporations. Providing legal advice is the practice of law, and restricted to licensed attorneys when the type of advice offered is generally only provided by lawyers. Latin for this occasion, or for this event, or for this turn, Pro Hac Vice is a temporary exception to the general rule that a lawyer must be licensed within the state in order to appear before the court or otherwise practice law within the state. A lawyer licensed in another state can request permission from the local court for Pro Hac Vice status. This may require a confirmation of the lawyer's standing from the state bar where she is licensed and the payment of a small fee. Permission is not guaranteed. A lawyer can be disbarred from her home state if she fails to request or gain Pro Hac Vice approval but proceeds to represent clients in court or otherwise practice law in another state. There is an exception to the rule that the attorney must be licensed by the state when his work arises out of a case or assignment in his own home state. The work in the state where he is unlicensed must be reasonably related to his work in his home state. It arises from or is an outgrowth of work in the state where the attorney is licensed. A common scenario is where an attorney has to travel across state boundaries to take a deposition of a witness in another state. An attorney working on a case in California may be forced to travel to Nevada to take a deposition of a witness residing in Nevada. Another scenario envisaged by the ABA rules involves an attorney required to travel across state lines for out-of-state mediation or arbitration. This exception allows attorneys to complete assignments for home state clients that involve matters crossing multiple states. There's an exception allowing a licensed attorney in one state to undertake temporary work in another state when associating with an attorney licensed in the other state. The associated locally licensed attorney, however, is required to actively participate in the assignment. Sometimes known as the squeal rule, a lawyer has a duty to report another lawyer for ethical violations under the ABA. This applies to situations involving serious professional misconduct. A violation must be reported when it raises a substantial question of the lawyer's honesty, trustworthiness, or fitness to practice law. Similarly, a lawyer has a duty to report ethical violations of judges. There is an exception where reporting would breach the lawyer's duty of client confidentiality. The duty to uphold the confidences of clients trumps the duty to report ethical violations of fellow lawyers and judges. The State Bar is able to sanction and discipline a lawyer for the violation of an ethics rule, but also for attempting to violate the rule or assisting another to violate the rule. Sanctions can be imposed for criminal conduct involving dishonesty, untrustworthiness, or unfitness to practice law. There are special rules designed to prevent lying, an activity even outside of legal work involving dishonesty, fraud, deceit, or misrepresentation can result in discipline from the State Bar. Sanctions can be imposed on a lawyer for any conduct prejudicial to the administration of justice. Implying an ability to improperly influence an official is misconduct, even when the implication is false. So telling a prospective client, "Hire me, the judge is my buddy," this is sanctionable regardless of whether or not the statement is true. Passing the buck to other lawyers is not easy. A lawyer can claim, "I didn't do it myself, it was my colleague," but will still be held responsible if he ratified the action of the other lawyer. A lawyer can claim, "I managed the team responsible, but I didn't do it myself," but the manager must take responsible, reasonable efforts to supervise subordinate lawyers and keep them from violating the regulations. The managing lawyer is also responsible if he ordered the conduct or was aware of ethical violations by his subordinates. A lawyer can claim, "My boss made me do it," but is relieved of responsibility only if the ethics question involved is debatable and his action was reasonable under the circumstances. The door is firmly closed on non-lawyers owning a law firm or any form of partnership interest in a law firm. Lawyers answer to their clients, and the regulation governing the legal profession is designed to prevent business influences from interfering with the client-attorney relationship. The idea is that lawyers answer only to their clients, not outside shareholders or non-lawyer business owners. Ownership of a law firm is restricted to lawyers. A law firm cannot appoint non-lawyer partners, a law firm cannot belong to a non-lawyer or non-lawyer investor shareholders, and lawyers cannot partner with non-lawyers if any of the activities undertaken together involve the practice of law. The attorney's key duties to the client include competence. The lawyer is required to prepare for the case, establish and maintain competence in order to effectively represent the client. Diligence. The lawyer should respond promptly to client requests and keep the client reasonably informed of the status. Diligence also means pursuing the matter to completion. A lawyer has a duty to maintain the client's confidences. This means the lawyer should avoid any gossip on the client's matters and assert the client-attorney privilege on behalf of the client when confidential information is requested by the state or others. The lawyer has a duty to provide independent judgment, and this means avoiding conflicts of interest. We'll discuss conflicts of interest and other duties more fully in other slides. But the general idea is that the lawyer acts as if this particular client is the lawyer's one and only interest, and the lawyer does not let any other interests or obligations affect his judgment. The lawyer has a duty to safeguard the client's property. One aspect of this requires the lawyer to separate the advances and other client funds from the lawyer's own funds. commingling of funds is taken very seriously and is grounds for dismissal from the bar. A disgruntled client is able to bring a malpractice claim for breach of these and other duties owed to clients by their attorneys. A malpractice claim by a client can be made under breach of contract and negligence, as well as other legal theories. However, negligence opens the door to punitive damages, an appealing remedy unavailable in breach of contract claims. The lawyer is responsible for his own negligence, as well as negligence of assistants and subordinates. Malpractice can be insured but not avoided. Insurance is available, but it's not mandated. A malpractice insurance is common in the legal profession, and the costs vary by the type of the practice. A lawyer cannot contract with a client to cap a malpractice claim. There is an exception here, where the client is represented by another lawyer in the formation of this particular contract. LLCs and other corporate liability shields are unavailable to law firms. Actions of a lawyer can result in both an ethics violation from the state bar and a malpractice claim from the client. An ethics violation is relevant evidence of malpractice, but is not controlling. An ethics violation does not create a presumption that malpractice took place. It's merely evidence for the court to consider when investigating potential malpractice. Also, compensation of the client does not avoid discipline from the bar. The ethics violation with subsequent discipline from the bar and the malpractice claim compensating the client are related but separate. The attorney's key duties to opposing parties include the duty to treat opposing counsel and opposing clients with fairness, courtesy, and respect. A lawyer representing one party has a duty to avoid contacting the opposing party directly and should channel communication with the other party via counsel. A lawyer has a duty to provide opponents with access to evidence and avoid tampering with or suppression of the evidence. The duty to respect discovery procedures means the lawyer should make only proper requests for discovery from the other side and make reasonable efforts to respond to requests coming from the other side. Witness evidence is important in the pursuit of justice, and the lawyer has a duty to avoid restricting or distorting evidence of witnesses. The attorney is restricted from making payments amounting to bribery. Only legitimate payments of expenses and legitimate fees are lawful. At trial, the court frowns on trickery by the attorney, and fair play is required. Counsel must avoid chicanery, such as referring to inadmissible evidence or asserting personal opinions. An attorney's duties to the court require the attorney to avoid frivolous lawsuits and pursue only claims with merit, expedite the case, while acting in the interests of the client. This means the lawyer is not forced to rush the case at the expense of the client's position. The attorney has a duty of candor to the court. Honesty is required, but the lawyer is not required to disclose facts that are harmful to his client's case. The duty of candor restricts the lawyer knowingly making false statements of facts. The lawyer is required to provide relevant law to the court when he is aware of the law and it's directly adverse to his client's case. If the attorney is aware of case law or statutory law that is directly adverse to the client's case, the attorney has a duty to disclose this law to the court. The duty of candor requires the attorney to encourage his client to avoid presenting false evidence. If the client refuses to take the advice of the attorney and proceeds with the presentation of false evidence, the lawyer has a duty to withdraw or disclose the falsity of the evidence to the court if withdrawal is not allowed. The lawyer is not required to disclose harmful facts, but has a duty to prevent false evidence being presented to the court and has a duty to alert the court when the attorney is aware of case law or statutes directly adverse to the client's case. When representing children and incompetence, the lawyer has a duty to retain a normal client-attorney relationship wherever reasonably possible. This means the lawyer should communicate with the client as well as with the client's guardian or representative. Under this special exception to the lawyer's ethical duty of confidentiality, the lawyer is allowed to reveal confidential information to the guardian or representative or the prospective guardian or representative in order to prevent substantial risk of harm to the client. Children and incompetents lack capacity to enter binding contracts, and in an emergency situation where the client faces imminent and irreparable harm, the lawyer is able to represent the child or incompetent client without first forming a client-attorney engagement contract. The Model Code and rules promulgated by the American Bar Association.